According to Article 38 of the ICJ, the aforementioned factors configure the ICRC as an important tool for legal decisions. The guidelines provided by the ICRC makes explicit the need to use the principle of distinction when defining a military objective located in an environmental area. This principle requires that when conducting an operation, the state must difference between civilian and civilian objects in one hand, and in the other hand, combatants and military objectives one to the other. An attack cannot be directed against the natural environment unless it is directed against a specific part of it that has become a military objective. Furthermore, the contribution that a distinct part of the natural environment makes to the military action must be both effective and directed towards the military action. UNWHOR, before conducting the attack, sent tracking drones so that the target hit was specific and accurate. There was no doubt that the military objective was clear, strategic, and meticulously planned. No civilian were hit, and the operation was successfully completed, representing a military advantage for the applicant. Thus, all military targets were in accordance with the international customary laws, regulation, as they were only intended to contain military menace.
Excuse me?
Yes,
could you please explain me more about what is the customary law?
What is a customary law?
Yes.
Yes, Your Honor. Your Excellency, an international norm becomes customary international law when there is evidence of a general practice accepted as law through a constant and virtually uniform usage among states over a period of time. According to Article 38, Clause 8 of the Statute of the International Court, this should be applied in the judicial decisions regulations. As well, UNWHOR did not violate international humanitarian law regarding its response to the ANPFF attacks. A humanitarian crime occurs if there is an international attack directed against civilians, according to, as stated earlier, the principle of distinction, which is not the case. Only members of the paramilitary group, combatants, were injured. And considering the principle of proportionality required in these situations, the strike configured itself as legitimate. The principle of proportionality, which is a general principle in law, states that the harm caused must be proportional and not excessive in relation to the concrete and direct military advantage anticipated. The military commander of the UNWHOR conducted a proportionality analysis and determined that the anticipated death and destruction was not excessive. The country attack that took place at the manhunt falls within the limits of proportionality, fully in accordance with international humanitarian law 14, considering that the only lives lost were those of members of the paramilitary group. The fire was not part of the plan and not premeditated, occurring primarily due to the respondents' withholding of important information. Secondly, Your Excellency, it is imperative to emphasize that UNWHOR did not infringe any environmental law concerning the fire. Despite wrongful accusations in its diplomatic notes that UNWHOR violated customary international law and committed a war crime in setting the complex on fire, it is important to note the falsity of those allegations. The prohibition of causing widespread long-term. Yes, Your Honor.
Could you please explain to me what do you consider a war crime?
Your Honor, according to the international humanitarian law, a war crime is the one that violates its general principle, such as the protection of civilian or objects that have civilian character. The prohibition of causing widespread long-term and severe damage to nature is reinforced only in the Additional Protocol 1, Articles 35 and 55 of the Geneva Convention, to which UNWHOR is not a signatory. This law has also not reached the customary character. Although Rule 45 of the International Humanitarian Law defines that the use of methods of means of warfare that are not intended or may be expected to cause widespread long-term and severe damage to the natural environment is prohibited, the character of this norm is dubious. As is already known, to acquire the character of customary law, a norm needs to be repeated by states regularly and accepted by opinion juries, which is not the case. The United States, France, and the United Kingdom are persistent objectors to this rule. France and the United Kingdom state that the risk of environmental damage failing within the scope of these provisions must be assessed objectively on the basis of the information available at the time. In their submissions to the...
Yes, please go on. Sorry. If you're concluding, please carry on.
As I was saying, in their submissions to the ICJ in the nuclear weapons case, and in the final report of the committee established to review the NATO bombing campaign against the Federal Republic of Yugoslavia, these countries affirmed that this rule was not customary. As well, the Statute of the International Court defined it as a war crime, intentionally launching an attack in the knowledge that such attack will cause widespread, long-term, and severe damage to the natural environment, establish an additional condition with respect to the criminalization of the prohibition contained in this rule. As already stated, UNWRA had no knowledge about the ecological character of the complex and did not use the environment as a weapon of war. The fire was not foreseen. In view of the uncertain nature of such prohibition, and given that UNWRA is not a signatory of the treaties that make explicit the illegality of fires and damage to the environment, it is more than clear that the country should not be held responsible for this fatality.
Agent, let me ask you something
Yes.
related with a different view. You were not attacking the respondent itself. You were attacking a military group that was within the respondent's territory. So even if the respondent withheld information from the Ramsar Convention, wouldn't you say that you had a duty to cooperate with the respondent to discuss with him before carrying out the attack? It's not as if you needed to surprise the respondent. They were not the objective. So if the objective was just within their territory, couldn't you have consulted with them on the best way to do and deal with that threat to your country?
Yes, Your Honor, I completely agree and understand what you're trying to imply. But it is important to emphasize the emergency nature of the country attack measure, considering that UNWRA was in an extremely vulnerable situation and susceptible to attacks. Warning of the attack would decrease its effectiveness, resulting in a possibly negative outcome, which is in accordance with IHL Rule 20, that states that each party to the conflict must give effective advance warning of attacks which may affect civilian population, which did not happen, unless circumstances do not permit. This warning is not required in cases where the element of surprise is essential to the success of an operation. Necessary speed of response is another consideration cited in practice as relevant to determining the feasibility of warnings. Furthermore, this rule also provides the warning must be only given to attacks which may, like I said, affect civilian populations, which do not occur. Considering that while the ANPFF set up camp at the wetland complex, Rome was aware and tolerate its presence on its territory, and who had suspicions about the country. By not reporting the prolonged drought that has been occurring on the man-hit complex since 2014, Rome violated the Ramsar Convention, making it impossible for UNWRA to foresee any environmental hazards. The Ramsar Convention postulates the obligation to report any significant climate change on its sites in its Article 3.2. The information regarding those changes should be passed without delay to the Ramsar Secretariat, according to Article 8. By withholding the information of the drought that has been occurring for at least 7 years in the complex, Rome will infringe that article. The unhurried artillery attack would not have caused the fire if the biological character of the complex had been within the regulations. According to the advisory note for land managers on rivers and wetland restoration from the government of Western Australia, many native flora and fauna from wetlands ecologicals are able to survive or recover from fire by resprouting from buds beneath their bark or from rootstock, germinating from seeds stored on their plants or in the soil, or able to reestablish in an area by recolonization. Natural, healthy wetlands hold decaying moss, lots of water, and support a living carpet of a special fire-resistant moss. In this way, the wetland can act as a fire break to restrict the fire from spreading. Given this information, it is evident that in an appropriate climate condition, the fire would not have taken extrapolated proportion, since the natural environment of wetlands provides natural fire control. The loss in fauna and flora in this case occurred much more due to inadequate climate conditions than necessary due to the fire. In view of this information, UNHUR cannot be held accountable for the consequences of the fire. A military attack was carried out according to the proportionality that the situation required and taking into account the previously known and environmental character of the complex. The chance that anything will go unplanned was minimal, considering that a counterattack was carried out, considering that unanticipated proportionality was carried out before the counterattack actually happens. However, if this court decides that the strike was actually a violation of an international rule, UNHUR is entitled to justify these acts under the principle of force majeure. Provided by Article 23 of the RCWA, the principle of force majeure exists to safeguard one state in relation to another, exempting the former from liability if its performance is affected by a supervening event, unforeseeable and uncontrollable, such as a natural disaster or war. As prior explanation, the wetland has had its ecological character adversely affected by a stranded rock since 2014, and this circumstance was the major cause of the fire. Therefore, there is a break in the causal nexus between the events, which constitutes a situation of force majeure, where an unforeseen event characterizes a circumstance precluding wrongfulness. Your Honor, to summarize, I would like you to judge and declare that UNHUR did not violated any international law with regard to the attack that took place at the Manhit Wetland Complex. UNHUR's attack was proportional to the information obtained about the complex. The fire situation was an unimaginable misfortune. As we've seen, wetland areas do not catch fire easily unless they are suffering from some unbalanced weather. There was no way to predict the effects of artillery on nature. Therefore, UNHUR bears no responsibility for what happened. The military attack cannot be considered as a definite causal link for the occurrence if a causal link for the occurrence of the fire. And bearing this in mind, it is not logical for Rongo to charge any compensations for damage. UNHUR did not perform wrongful acts under international law, and this is explicitly defined in the Costa Rica versus Nicaragua case, where this court determined that in order to have environmental compensations, there has to exist direct and certain causal links between the damage and the activities of the state. And with that, I conclude my submissions, Your Excellencies. Do you have any further questions? Thank you. It has been an honor arguing before this court.
Oh, I can talk. Good morning, Madam President, members of this court, and agents of the respondent. My name is Ana Beatriz Oliveira from Team 2653, and I'll be arguing today on behalf of the Federal States of UNHUR, the applicant in this case. And as my co-agent has already mentioned, I will speak for 13 minutes. Doing a briefly a statement of fact, after illegitimately occupying the island of Camp Key, part of UNHUR since colonial times, the state of Rongo has announced the construction of a hotel complex comprising 2 buildings, 12 stories high, 4 restaurants, a marina, and other facilities in an area recognized as a rapture site. The hotel complex will cover 17 hectares immediately adjacent to a Ridley nesting habitat, and the marina will be seated exactly on part of the nesting habitat of this endangered species. Hence, leaving aside the illegitimate occupation since it's not part of this court's decision, it will be demonstrated the non-compliance with international law. It is a fact, as we made explicit, that A, Rongo violates the Ramsar Convention, B, Rongo violates the international duty to consult and cooperate, considering that the Rio Ridley is a migratory species. C, the risk to Rio Ridley also implies a violation of the Inter-American Convention for the Protection and Conservation of Sea Turtles and the Convention on Biological Diversity. And lastly, the measures identified by the EIA, the Environmental Impact Assessment, are not sufficient to preserve the Rio Ridley. Firstly, concerning the Ramsar Convention, Your Excellencies, it is necessary to point out that by being part of the convention, a contracting part is in agreement with it and therefore recognizes its decisions. The statement that Rongo does not consider the Sud coastal wetland as a Ramsar site is unacceptable. This area was already recognized as being a wetland of international importance, and this does not change with Rongo's illegitimate occupation of Camp Key. This is something, Your Excellencies, very important to pay attention to, since by discrediting the status of highest relevance for a wetland, it is clear the correlation between this devaluation of the ecological status and the economic intentions of the construction of a hotel complex. And this is a central point of violation of this convention, since the RAMSR values in the first place the protection of the wetland and not interventionist activities, with special attention to this case, since it puts a serious risk on already critically endangered species. Article 3.1 of the RAMSR Convention, mentioned in our diplomatic note sent on October 4, 2020, requires the obligation to implement plans for the promotion of conservation. The proposed project will result in wetland loss, therefore loss of biodiversity. And properly using words present in the resolution 11.9, avoiding wetland losses has been the overall objective of the RAMSR Convention since 1971. Moreover, the project entails the risk for irreparable losses, such as the critically endangered rural species, part of the ecological character of the wetland. Rongo also does not respect the guidelines of wise use of the wetlands presented also in Article 3.1, since it goes against the maintenance of its ecological character. Here it is important to present the definition of wise use, reiterated by Resolution 11.9. Wise use is in accordance with the maintenance of their ecological character, achieved through the implementation of ecosystem approaches within the context of sustainable development. The meaning of wise use is in the order of maintaining the ecological character of the wetland.
Yes, I have a question.
Yes.
Doesn't the Roma resolution in Article 11.7 on tourism, recreation, and wetlands encourage these types of projects?
Yes, Your Excellency, but encourages these types of project in Resolution 11.7 if the ecological character is maintained, which is not will occur in the case of the Sud coastal wetland, because the marina will be seated exactly on part of their nesting habitat, and no measures were identified through the environment impact assessment to this problem.
Agent, building on that, walk me through a little bit here. What are the differences between the responsibilities of the respondent in face of the RAMSR Convention, depending on whether we recognize Camp Key as a territory of the applicant or the respondent? Do the obligations change? And what is your current standing about whether Camp Key is a territory of the applicant or the respondent?
Your Excellency, if the territory correctly after this first decision will be verified as being a part of the Unwilling territory, there will be a violation of the transbordering harm by Rongo announcing a project in our territory. And as the hypothesis for they have the sovereignty over the island, is still the project violates international law, as we are mentioning here, the RAMSR Convention, for example, the mentioned Article 3.1, since the project do not guarantee the maintenance of the ecological character and the conservation of the wetland. And the Article 3.1, Your Excellency. Oh.
Just to add on that, especially you've been talking a lot about Article 3.1, and as many conventions in international environmental law, they have limiting language. So if you read Article 3, in the end it says, parties shall promote conservation of wetlands as far as possible, as far as possible, the wisest use of wetlands. So doesn't this sort of language, as far as possible, just literally mean that they can do any sort of effort and that will be enough, even if they just do very little? They can just say, I did it as far as possible. So how do we deal with those kind of languages? Is it binding? Is it non-binding?
Your Excellency, consider the RAMSR Convention, which are binding, since both parts are a part of the convention, and according to Article 38, is a primary source of international law. The case of wise use mentioned in the Article 3.1, it is not valid because it has a strong impact, the hotel complex, on already endangered species, and is not even in a sustainable project claim guaranteeing the maintenance of the ecological character. Therefore, the statement that the proposed hotel development is in accordance with the wise use principle, it is not correct. And Your Excellency, the Article 3.1 is directed at wetlands included on the list, which is the case of the Sud coastal wetland. But even under the claim that the wetland is not a RAMSR site, there is a violation of Article 4.1, which also states that contracting parties should promote the conservation of wetlands as well as water populations. And it is necessary to pay due regard in this point, the decrease in water populations that will be caused by the construction of a hotel complex. Waterfall movement patterns change in response to human activities and in view of wetland loss and degradation. Therefore, the project goes against Article 4.4 of the REMSHA, which applies whether it is a wetland included or not in the list. It is fundamental to focus attention now on a point recognized in several resolutions, especially in Resolution 11.9, which is violated by the respondent. The parties are aware that the Convention guides an approach that must be taken to respond to current or likely changes in the ecological character of wetlands, regardless of they are or not included on the list. The three-step approach is 1, avoiding impacts, 2, mitigating for unavoidable impacts, and 3, compensating for remaining impacts. Rongo does not comply with the first step, which is enough to invalidate the project. The construction of a hotel complex that includes 4 restaurants, parking lots, and a marina that will be seated exactly on part of the Ridley's nesting habitat is not compliant with the avoidance of impacts. According to the resolution, where such avoidance is not feasible, should the country undergo the other steps. The execution of this project is completely avoidable, and Rongo should have already looked for another place to execute it, one that does not cause wetland laws and thus does not violate the guidelines of an international document that seeks to preserve the environment. Addressing the second point, the Rio Ridley spends part of its life cycle in the territorial waters of Corfu, as mentioned in the report, being a migratory species, as acknowledged also by the IEC, and as highlighted in Resolution 13.24, that it states that the species Lambidosh scampi, which shares many of the same characteristics as the Rio Ridley, in order to live and survive, depends on a variety of coastal habitats through the life cycle. In view of this fact, Rongo, the announcement of the hotel complex, indicates a violation of general principles of international law. In accordance with Article 5 of the REMSHA Convention, Rongo should comply with its duty to consult and cooperate in view of the shared species along the sea roads. Also, Your Excellencies, with this posture, Rongo violated the IEC that recognizes that the protection and conservation of migratory sea turtles require cooperation and coordination among states, and violates Article 14.c of the CBD, that it says that contracting parties have the responsibility to promote exchange of information and consultation on activities that are likely to adversely impact areas beyond their national jurisdiction. Besides not complying with the duty to consult and cooperate, Rongo's actions will result, yes.
Let me take that. I think that part is a bit more clear. Let me take it back to my other point about the responsibilities, about the respondent considering that the territory is disputed. A similar situation happened in Crimea. So are you familiar with that situation? The Crimea annexation and the responsibilities of Ramsar sites from Russia. Are you familiar with that situation?
I'm sorry, Excellency, I have a lack of information in this case right now.
All right, no worries. Well, carry on.
Okay. But besides not complying with the duty to consult and cooperate, Rongo's actions will result in the violation of the duty to prevent transbordering harm, also recognized as a customary law in the Pope Mills case, mentioned in Article 3 of the CBD and Principle 21 of the Stockholm Conference. According to this duty, a state has the obligation to use all means available in order to avoid activities from causing a significant damage to the environment of another state. If the hotel complex is built, Rongo will cause damage to a shared resource. There is a critically endangered species, thus causing a significant impact in light of your extreme vulnerability. Addressing the last point, the measures identified through the EIA are not sufficient to remedy the risk to Rio Ridley. Therefore, Rongo violates Article 4 of the IC that requires the preservation of sea turtles nesting areas and attests that there must be a restriction of human activities that can seriously affect sea turtles, especially during the periods of nesting. And as a complement to this violation, COP decision 8/28/28 from the CBD ensures that states must refrain from engaging in an activity if such results in the extinction of an endangered species. In order to better explain the grounds for this violation, it is necessary to mention that the precautionary measures indicated by the EIA were directed only to the problem of light pollution, and they do not guarantee total protection. The installation of shade screens or window tinting is a frequently used alternative, but because sea turtles' hatchlings are extremely sensitive to light, they do not provide a full protection to the reproductive success of the Rio Ridley. Sea turtles' hatchlings are guided to the ocean at night by the natural light on the ocean horizon. And beachfront lightning disorients hatchlings when they emerge from the nest, leading them away from the water and towards roads and buildings and vehicles, as well as other obstacles. Moreover, the marina will be seated in part of their nesting habitat, and the use of the spotlight will be kept exactly in this place. Therefore, besides the installation of shade screens not being fully protected, there will be still full white interference in the marina that holds 35% of the gnats from the global railroad population. Hence, the EIA did not indicate effective measures. In addition to the presence of light pollution,
I have a question. So, Rongo conducted an environmental impact assessment before, and is requiring certain measures to address the hotel lighting. So, this isn't enough under the international law.
Your Excellency, they do the environmental impact assessment according to their national law, which is in accordance as mentioned by the Pope Mills case. But the measures indicated were not sufficient and do not cover all problems that will put the railroad in risk. Can I just finish my argument, Your Excellency, about the marina being seated exactly on part of the nesting habitat? In Florida, for example, mostly turtles' deaths are the result of collisions with boats. Already endangered species cannot be left at the mercy of these factors, even more so because it is a fact that protective measures of any kind have been presented to the presence of the marina in their nesting habitat. In this sense, it is also it is important to emphasize the violation of paragraph 3 of Annex 2 of the IC, which established that the parts must promote restriction on vessel traffic, which was also not addressed in the EIA. With these considerations, I conclude my speech, Your Excellencies. Thank you. It had been an honor to argue before this court.
Thank you, Agent. Pessoal, só um momento. A professora Solange, ela está com problemas de conexão de internet, por isso que ela não pôde acessar antes e continua com a internet um pouco instável agora, pela mensagem que ela me enviou. Vamos ver se ela consegue falar agora. Olá, professora. Acho que está silenciada por hora, não sei se consegue me ouvir também.
Agora consigo ouvir, desculpem, gente.
Perfeito.
Problemas de conexão que a gente não connection problems, and so here am I.
Sem problemas, tudo bem. Então, nós vamos agora passar para a segunda equipe desta rodada. E você pode fazer perguntas a qualquer momento, como sempre, e depois nós ajustamos na questão da avaliação e possivelmente você participa da próxima rodada integralmente.
Okay, perfect.
Yeah, perfect. Okay, so the first agent for the respondent, Maria Beatriz, for 17 minutes, correct?
Yes.
All right, just a second, let me set the timer here. You may proceed whenever you feel like it.
Thank you. Your Excellencies, may I please record? I hope you can hear me well. My name is Maria Beatriz Montenegro, acting on behalf of the respondent in this proceeding. I will be using 17 minutes, as announced, to present that the applicant's attack on the Humanitarian complex violates international law on the 3 arguments. 1, it violates the rules of use of force. 2, it violates humanitarian law. And 3, it violates environmental law. My co-agent will later enumerate and present her points. If I may, under the first violation, and her breaches the use cogent prohibition found in the UN Charter, which prohibits the use of force against the territory of another state, unless it's self-defense. However, the applicant forgets that the justification of self-defense.
Se não for essa, você pode. Oh, sorry.
That's okay. The justification of self-defense is exclusive to interstate situations, as the ICJ already confirmed in the US versus Nicaragua case, as well as in the Wall advisory opinion, that self-defense can only be invoked to defend against an attack made by another state, which was not the case. Besides this, the execution of an extraterritorial self-defense must meet certain requirements. For instance, then there must be an invitation or consent, as the ICJ has confirmed it in the US versus Nicaragua, or a request to the United Nations Security Council to allow for authorization, which did not happen, or the proof that the state is unable or unwilling to deal with the non-state actor in its territory, which was confirmed in the Congo case, which was also not the case. Your Honor, the record and the record clarifications confirm that there is no evidence that Rongo knew of any planned military operations by the group. This is under clarification number 10. Secondly, the state of necessity cannot be claimed here because, as the ICJ recognized in the Gabikova Jimaros project case, a state of necessity can only be used if the action does not harm an essential interest of another state. And in that case, like the Covenant Marriage Project case, the ICJ even recognizes that environmental preservation and concerns is exactly an example of essential interest which prevents invoking a state of necessity. Now, force majeure, which was exactly what the applicant has been claiming in this oral procedure, relates to an event which triggers an involuntary action by the state involving no element of free choice, therefore making it materially impossible to perform an obligation. Adler, however, was never forced to launch 200 high explosive rounds the way that it did, irresponsibly, without warning, without mitigation. Besides, the environmental obligations that it has to wrongful were never made materially impossible, and force majeure only covers the circumstances made by performances that make the performance impossible and not simply difficult. Therefore, no circumstances actually of general rules of state responsibility can preclude the applicant's wrongfulness. Now I enter my second type of violation.
Before you enter that, I understand all your points here about what they should have done in terms of, what they should not have done in terms of attacking the territory, like the wetland. But quite honestly, what could they have done legally and feasibly to protect their essential interests, which were being attacked from your territory, and considering that your territory did not send military to that area? So what could the respondent have done, in your view, legally to protect themselves? Sorry, the applicant.
Sure. I like to recall that the ICJ's decision on the nuclear weapons advisory opinion, when it confirmed that requirements for using self-defense would be conditioned to necessity, for example. In this sense, it is in my view that at least Rongo should have been given the opportunity to deal with the non-state actor through its own law enforcement or other lawful measures. And this should be viewed as a preferred solution, and the necessity principle would require it to be pursued with reasonable bounds before force is employed. Therefore, at least communication could have happened. As I will explain, notification is actually an environmental obligation that the state owns to another state if there is any risk of causing environmental damage to that other state. This will, however, be my third point on the environmental obligations. The second point, however, is the humanitarian obligations that the applicant has breached. And Your Honors, self-defense, state of necessity, force majeure, they cannot justify humanitarian law violations, which are peremptory norms of international law, as the wrongful character of their violation cannot be precluded except for circumstances specific to the field, which is, for example, military necessity, as the applicant has been claiming. However, as the ICRC, which is already recognized by the applicant and we recognize as well, it mentions in Rule 43 that destruction of any part of the natural environment is prohibited unless required by imperative military necessity. This is the only excuse, but Anher cannot claim it. This is because military necessity is not an absolute justification. One of the requirements is actually that the measure is not prohibited by humanitarian law. This was also already recognized by the ICJ in the Wall Advisory Opinion, that an action which is unlawful in war, meaning that it's not in line with humanitarian law, prohibits the use of the necessity waiver. For example, the ICJ said that despite Israel's right to protect the civilian lives, the measures taken under military necessity are still bound to remain in conformity with applicable international law, and that the violations of humanitarian law cannot be justified by military exigencies. Similarly, in our case, Anher cannot plead the exception of military necessity to justify an operation which was unlawful. Now, why was the operation unlawful actually? First, it was unlawful because it struck protected objects, since a wetland is a water reserve and water is a protected object in warfare under Rule 54 of the ICRC, which cannot be attacked in any circumstances. Secondly, the operation constituted what is known as an indiscriminate attack, which is prohibited by humanitarian law. Since customary definitions of indiscriminate attacks include under Rule 12 of the ICRC, those attacks which employ means of methods whose effect cannot be controlled or limited as required by humanitarian law, and consequently will strike both military and civilian objects without distinction. This was exactly what happened because the effects of launching 200 high explosive artillery rounds could not have been controlled or limited to only affect the military camp and not the rest of the wetland as well. Civilian objects, Your Honors, are what customary law defines in negative terms as objects which are not military objectives. And customary Rule 43 confirms that no part of the natural environment may be attacked unless it is a military objective. This means that the environment is civilian by default. There is no requirement that there must be civilians living there. This prerequisite does not exist under international law, and the applicant has been failing to deliver on such justification. Therefore,
don't you think that it sounds much like a loophole in the law, that if a military group, paramilitary group, goes and decides to set base in a protected Ramsar site, then they can just throw rockets at the other country and they can't be attacked? It sounds like that's the situation here. Just because they chose to set base in the man-made wetland complex, that they can do anything and they cannot be attacked. What are the other solutions if they cannot fire missiles there?
Thank you, Anna, for your question. This situation of attacking non-state actors on other countries extraterritorially is been dealing, for example, with terrorist attacks, such as on the Islamic State. However, it has been consolidated in international law as what is usually required is an authorization of the state, which in its environment, in its territory, the military group would be located. There is no communication, there is no cooperation, there is no responsibility, there is no consultation. And we understand that this would be an emergency situation, but this does not create an automatic license for a state to launch an attack against the territory of another state. This would be extremely dangerous to international law as well. Did I answer your question, Your Honor? Thank you. So regarding the indiscriminate attack that was launched, this is because international law demands that all operations in war are able to discriminate between civilian and military objects. And even if the camp was a military object, as the applicant has recognized and Rommel recognizes as well, the surrounding area was not. Therefore, the applicant ignored this when it decided to launch explosive artillery.
Excuse me?
Yes, Your Honor.
I have a question, because you mentioned some of the rules that could be not considered by the attack, but in this case, the principle of proportionality was not respected.
Indeed, it was, and it was also violated by the applicant, because, for instance, a reason that this attack was unlawful is that it delivered what are known as prohibited environmental damages. There are two instances of prohibited environmental damages in war, one being the widespread, long-term, and severe damage. And even if that is not recognized as customarily applicable in this case, excessive environmental damage is also prohibited. For instance, when we look into Rule 43 of the ICRC, it states in paragraph 3 that launching an attack which might have been expected to cause incidental damage to the environment, which would have been excessive, is prohibited. This highlights that incidental damage is also part of the calculation of proportionality, and the belligerent is also liable for the attack's indirect effects on the environment, even if it did not desire that damage. Therefore, there is no break of the causation link as the applicant has acquired. Your Honor, for using drones to analyze the location, as ANHR did, they had visual information of the area's condition, including the drought. In this case, for the crucial value of the area, ANHR cannot claim ignorance to the fact that the damage would have been sufficient, would have been considerable and severe. It was a Ramsar site of international importance, a fragile ecosystem home to several endangered species, a water reserve, and this makes it excessive in a way that the applicant could have known it. In this sense, the applicant also breaches the duty, which is of taking precautionary measures. And for instance, in customary rule 19 of the ICRC, it states that when there are threats of damages which are prohibited by international law, the attacker is under a duty to refrain from launching that attack. Moreover, Rule 44 reminds us that, quote, I'm going to read it, lack of scientific certainty as to the effects on the environment of certain military operations do not absolve a party to the conflict from taking such precautions. And using drones was not a sufficient precaution. It only found the target that they needed. ANHR still chose to launch 200 high explosive artillery rounds in a foreseeably affected environment. And also, when they mentioned that wetland would be wetlands which would be inadequate conditions would not be passable for fire is actually not true. When we regard their memorial, actually the reference that they used was a 2-page document which recognized that natural fires are a relevant ecological factor for wetland ecosystems, but that human action makes wetland fires more frequent. And we agree with that. In fact, the fact that a human action of launching 200 high artillery rounds, explosive rounds, against a forest would have made it foreseeably increasing the damages, the chances of firing, of the fire spreading through the foliage. It was a foliage and water-based environment that would have had the fire spread. Also continuing on other reasons about why this is a prohibited damage. As I said, we're dealing with a protected object because water is protected under international law. And when we look into also other protected objects, we find cultural property, unless it is imperatively required by military necessity. But as we have established, military necessity cannot be used by the applicant if its actions is still not in line with humanitarian law. Your Honor, for all that has been said, for unlawfully using force against wrongful, for launching an indiscriminate attack, striking protected objects, for taking insufficient preventive measures, for causing environmental damage which is prohibited in an area of international importance, and for the fact that incidental damage, even if not desired by the attacker, is still accounted for under those obligations, and for the fact that no reasons can preclude wrongs and whose wrongfulness. In this case, we request that the ICJ judges that Anher violated the rules of use of force and humanitarian law. Now, my final argument is that Anher violated environmental law. This is because environmental
Excuse me?
Yes, Your Honor.
I have another question. So ANUR is not a party to the additional protocol of 1977 to the Geneva Convention of 1949, and that contains the rule that prohibiting widespread, long-term, and severe damage to the environment. So how can that rule then can be applied to the ANUR's conduct?
Actually, it is recognized by the ICRC under Rule 45 that it is customary international law. The only doubt that they have is if it's applicable to non-international armed conflict as well as international, because it's solidified that international armed conflict that is customary to it. We do sustain, however, that even if it's not customarily recognized to be applicable to non-international armed conflicts, the damage would still have been prohibited under all of the other reasons, for being excessive, for being an attack directed to a protected object, and for having been executed in an indiscriminatory way. Because even if the target was a military object, the execution of that attack make the attack indiscriminate for the ways that they have been managing it. Does that answer your question, Your Honor? Even if it's not customary. Regarding the environmental obligations, Anher has breached many, and this ICJ recognizes that environmental obligations are not suspended or terminated in times of conflict. It has recognized this in the nuclear test case between New Zealand and France, and also reaffirmed in the nuclear weapons advisory opinion. Therefore, if I may list many environmental obligations that the applicant has violated due to its attack, the duty not to cause harm to another state's environment as established in Article 3 of CBD, which is binding to the parties and recognized by the ICJ as customary law in the Corfu chain case. Also, the customary duty not to cause transboundary harm as recognized in the pulp mills and nuclear weapons cases. Principles of the Rio Declaration, which even if it's not binding to the parties, has the principle similarly established in Rule 14 of CBD, which is binding to the parties, to immediately notify the potentially affected states of dangers or damages and to act to prevent and minimize such damages. Anher did not act to minimize it at all. It saw the fire spreading and it did not take any measures. Even if preventive measures were applied with drones, Anher is still bound to duties to mitigate and ensure that the extension of the damage would have been contained and help to restore the area. Moreover, it violated the duty not to take any deliberate measures which might have damaged directly or indirectly the cultural and natural heritage of parties to the World Heritage Convention. This is a rule found in Article 6, which is applicable to all heritage, even if not in the World Heritage List. Therefore, Your Honor, for all that has been exposed, we reaffirm our submission that the court should declare that the applicant has violated environmental law with its military attack. If there are no more questions, I finish my pledges and hand it over to my co-agent.
Thank you, agent. The second agent for the applicant may proceed for 13 minutes. Is that correct?
Yes.
Yeah,
Does
let's
you want?
me.
Yeah.
Okay. Honorable judges and agents for the applicant. My name is Beatriz Casado, and I'm also representing the respondent in this proceeding. I'll be delivering two remaining submissions, which are that first, and who is under a duty to pay compensation, and second, Rongo does not violate international law with respect to the proposed hotel project. Because of all that was exposed, and who is under a duty to provide full reparation for all of the international law violations that it caused. An internationally wrongful act of a state entails its liability and its obligations to full reparation, which includes damage made to the environment in and of itself. This was confirmed in the ICJ in the Costa Rica versus Nicaragua case, when the court also established that evaluating the compensation must be done from the perspective of the ecosystem as a whole and assessing the overall loss of environmental goods and services. This is likewise expected in this case as fragile and crucial habitats and ecosystems were injured. And even if the wrongful character of Enhu's actions is somehow excluded, despite all evidence in contrary, it still has a duty of compensation for the loss caused by its acts. This is also foreseen in the Article 27 of the Articles on State Responsibilities, which says that invocation of a circumstance precluding wrongfulness is without prejudice to the question of compensation for any material loss caused by the act in question. Moving to my second submission, Rongo does not violate international law with respect to the hotel project. First of all, we reaffirm the commitment to not discuss the sovereign dispute over the camp key, even if the applicant, contrary the principle of good faith, insists in bringing it up on its memorial. And as the applicant, with the applicant's own words, it is undeniable that Rongo currently possesses the ultimate legislative order over the territory. And in this sense, Your Honors, Rongo is sovereign to remove the Skoto Coastal from the Ramsar list. Under the Vienna Convention on Succession of States, in respect to treaties, international obligations cease to be enforced against new sovereign rule. This goes in line with the Vienna Convention on Law of Treaties, which solidifies the requirement of free consent of the state authority. Moreover, relevant documents confirm that state succession does not automatically impose previous obligations to the new sovereign authority without consent, and Rongo does not consent to have the skewed coastal wetland listed as a Ramsar site, and this must be respected. Secondly, I would like to inform the court that the Ramsar Resolution 11.9 consolidates that the Convention's obligations are only binding for listed wetlands. For the non-listed ones, it is only a recommendatory and, in the end, only considered as a good practice. Therefore, Rongo cannot, in any case whatsoever, have violated the Ramsar Convention with respect to the skewed coastal wetland. Still, even if the obligations for the Ramsar sites were considered, Rongo did not violate the convention, as the hotel project is in line with international guidelines. The Article 2.3
just quickly, before you proceed to the second point about not violating, on the first point about not being bound by obligations, so you have 2 points, if I'm not mistaken. So one is that it could remove it from the list, and the second one is that they don't inherit obligations when they become a new state. But let's consider that it did not, because it's not very clear that the respondent has become sovereign in that territory. So, but anyway, if it were to delist something from the Ramsar list, what are the procedures there? What are the requirements for doing that?
I'm sorry, I'm not sure if I quite understood.
Yeah, let me.
Okay.
Right. So in summary, if they wanted to remove the Ramsar site from the Ramsar list, are there any steps, procedures to do that?
Well, Your Honor, in fact, as I said before, regarding the state section, it is not viable to just impose an obligation that was assumed by the state that existed before, because because the Vienna Convention on Cession of States in respect of treaties says that the treaties of the predecessor states cease to be enforced in respect of the territory to which the succession of states relates from the date of the succession. So therefore, that's why the Ramsar Convention should not apply over considering the Camp Key as a Ramsar site. Okay. So even if the obligations of the Ramsar sites were considered, as I said before, Rongo did not violate the convention because the hotel project is in line with international guidelines. And Article 2.3 of the Ramsar Convention says that the inclusion of a wetland in a list does not prejudice the sovereign rights of the state. One of those rights is to achieve sustainable development. So Rongo's aspiration with ecotourism activities, which I shall say that the applicant actually recognized on its memorial as a project of ecotourism, is in harmony with several international documents, such as the Rio +20 and the Ramsar Resolution 11.7, which confirms that those activities in and around the wetlands are successful in aligning both biodiversity, conservation, poverty alleviation, local empowerment, and human health. So, Your Honors, there is no trade-off between social and economic development and conservation, because sustainable tourism is able to address both issues, and this is what the state of Rongo wants. The Resolution 11.7, in fact, incentivizes.
Excuse me?
Yes, Your Honor.
Could you explain me what do you consider to be a sustainable tourism?
Yes, Your Honor. The sustainable tourism is aligned with the sustainable development context, which is an approach from the Ramsar Convention, which conjugates ecological responsibilities with wider and long-term social and economical needs. Moreover, this aligned with this concept, the ICJ in the Gabi Kovo-Najimaras project case already recognized the importance of the sustainable development. And this is the case, Your Honor, since the hotel development will congregate educational purpose with also the conservation of the Ramsars, of the area over the sovereignty of Rongo. So, did I answer your question? Okay. So, Rongo is acting with due diligence, Your Honor, and good faith, conducting an environment impact assessment, instituting mitigation measures, thus fulfilling its obligations under a Ramsar Resolution 8.4 and 11. It is exercising its best effort to prevent and avoid environmental harm by incorporating accepted international standards, fulfilling its duty of due diligence to prevent transboundary harm. The applicant claims that ecotourism project will decrease in waterfowl populations, but this is an unfounded allegation, Your Honors. All of Rongo's decisions are based and will continue to be based on an environment impact assessment, which is recognized by the ICJ in the pulp mills case as a sovereign activity of the country that will implement the activities, which has also the authority to indicate the specific content of the study that will be required in each case. And in line with the studies, Rongo complies with, I'm sorry. Just knowing the Siri. Okay. In line with the studies, Rongo complies with the obligation to mitigate damages. And the applicant claimed that Rongo is not compliant with avoidance of impacts, but avoiding impacts is exactly the objective of an impact study, by determining that it will only authorize the construction of if the mitigation measures are fulfilled. Rongo is compliant with its studies. And by reviewing its wetland management plans and seeking to ensure the inclusion of marine territorial conservation actions, Rongo is in no contradiction. Finally, we'd like to stress that the applicant claims that Rongo violated the World Heritage Convention and the duty to notify on its memorial. First of all, they say that the skewed coastal wetland is classified as a World Natural Heritage, but this information is nowhere to be found in the fact sheet. Second, in order to justify the notification duty under customary law, they mentioned precedents of the San Juan and Pope Mills case. As a matter of fact, Your Honors, the San Juan case confirmed that Article 5 of the Ramsar Convention, besides containing a general obligation to consult about implementing obligations arising from the convention, it does not, in fact, create an obligation to consult concerning a particular project that the state is undertaking. In the Pope Mills, on the other hand, the duty to notify that was indicated was the one found in the statute of the Rio Uruguay, which is restricted to Argentina and Uruguay. So now, nowhere in any of those cases did the ICJ recognize a duty to notify as a customary law in each and every case of a domestic project. And actually, Your Honors, in Costa Rica versus Nicaragua, the ICJ affirmed that because Nicaragua conducted a study and found the absence of risk of transboundary harm, it was not required to notify or consult with Costa Rica. The environment impact assessment carefully conducted by Rongo denied any causation of a substantial change to the environment of NHU, which is the definition of harm in transboundary harm that must be significant. There is no duty to notify about something which was not even found to be real, Your Honors. So, in conclusion, Rongo is conducting the project in good faith and with full due diligence within sovereign rights, taking necessary steps to reduce and or avoid damages to the skewed coastal ecosystem as a whole. The hotel, Your Honors, will compromise just a minimal area of the island that corresponds to 0.6% of it. And that won't, in contrary to what NHU claims, change the ecological character of all the region, since its conservation always was part of Rongo's agenda. So in summary, Rongo did not violate the Ramsar Convention nor the World Heritage Convention. Second, there's no evidence that there is a decrease in the waterfowl population would be caused by the hotel project. Third, Rongo fulfills its studies with prevention following international recommendations. And fourth, Rongo does not violate any duty of notification. So we conclude by reaffirming our submissions that NHU violated international law with its military attack and that Rongo does not violate international law with the HODL project. If there are no further questions, it has been an honor. Thank you very much.
Thank you, Agent. All right, so for the first, who's going to be the agent during the rebuttal? Laura, okay.
Your Excellency,
sorry.
Your Excellency, concerning the first claim, the reality of the attack was that only members of the paramilitary group were injured. No humanitarian law was violated. The use of force by UNWRA is justifiable under the principle of self-defense in Article 51 of the UN Charter, which permits the use of military force when responding to armed attacks. The principle of necessity also encompasses the strike, since it was the only way for UNWRA to safeguard itself against a grave and imminent peril. As well, contrary to the affirmation of the respondent, there appears to be insufficient uniformity of opinion on whether environmental law treaties continue to be applicable during armed conflicts. In his advisory opinion in the Declarations case, the ICJ did not address this issue directly. But alternatively, if the court does consider such a rule to be customary law, even in the face of war, it is important to keep in mind that the ICJ has never recognized environmental law as jus cogens. It is important as well to note that UNWRA did not infringe the World Heritage Convention. The complex is not part of the list and also cannot be understood as a natural heritage and not being covered by the obligations and limitations of the WHC. As already stated, this court determined in the Costa Rica versus Nicaragua case and the responsibility of states for internationally wrongful acts that there has to exist a direct and causal link between the damage and the activities of the state. UNWRA conducted all proportionalities and regulation according to the information it had. With respect to the second claim, it is a fact that the proposed hotel development is in violation of the international law, since it violates primarily sources of international law, such as conventions, precisely the Ramsar, the IAC, and the CBD, and general principles, as the duty to consult and compensate as presented in Gramsci Article 5. Then, it is an obligation of a convention. Moreover, the EIA, although duly following national laws, do not present effective measures, since spotlight will keep in the marine, as stated in the record, page 35. Thus, there will still be light pollution at the site, where 35% of the royal riding lasting area of critically endangered species is located. Thank you, Your Excellencies.
Thank you, Agent, and that concludes the submissions for this session. I will now take me and Professor Natalie to a separate room so we can discuss and judge your scores. Natalie, you should receive an invitation to join another room there.
Você pode
E
falar.
aí, gente?
Tem aqui esse timer aí contando horas negativas.
Sim, gente, vocês são das de... É que eu não ouvi na hora que fala entre a gente, né?
Pode.
Ah, vocês são das de Pernambuco, né?
Sim,
Sim, você sabe
eu...
Eu tô em Recife quase todo ano, velho. Eu tava lá, janeiro agora. Adoro, eu tenho
vocês são de
prima lá.
onde?
A gente
Eu
é
sou
da
de
Bahia.
Salvador.
Eu
Da
também
UFBA.
vivo na Bahia, porque meu pai mora aí. Ele é professor da UFBA. E aí minhas irmãs também são baianas.
Ele é professor de que departamento?
Mas ele é de música. Eu não, acho que vocês não vão
entendi.
conhecer.
Top.
Gente, vocês foram maravilhosas.
Ai, vocês também.
Vocês também.
Ai, seu sotaque é muito bom de ouvir, o da Bia, velho.
O sotaque normal e o sotaque falando inglês. Que você
Exato, é
eu
meio
achei,
British.
quando você tava falando, eu fiquei assim, ai, Jesus Cristo. Queria
Muito
saber.
bom.
Não, isso é um alter ego meu, na realidade, esse sotaque, quando eu falo inglês. Porque eu não sei o que é. Desce um pincher britânico, sabe? Eu nunca aprendi inglês britânico, mas aparece, assim, de vez em quando umas sotaques. Mas, enfim, gente, foi ótimo, sério, eu achei incrível.
Eu também
É boa
achei.
essa experiência.
Mas...
E é tão, assim, leve a condução que o Rui faz, é muito bom. Mari, eu tinha visto na última competição, então foi excelente agora.
Misericórdia.
Vocês chegaram a ver o round da gente do ano passado?
Não.
Eu vi. Você tava? Eu só vi a Maria.
Não, Bia não tava, não.
Você viu a
Ah,
final?
tá, eu vi a Maria. Não lembro.
Caos.
Não, foi um caso, minha gente. A minha primeira foi, assim, aterrorizante. Eu fiquei muito nervosa. Mas, assim, é isso. A gente vai competindo.
Essa da UFB é a primeira de todo mundo. Porque tem nós duas e tem uma que é o do Respondent. No primeiro
sim.
ponto. Aí, primeira vez da gente nesse teste. Né? Em qualquer competição, na verdade, né?
Ai, que massa. A gente sempre encontra um pessoal da UFBA nas competições, né, Bia?
Tem muito. Vocês estão em que semestre?
No 10.
Quase.
Eu tô, assim, postergando minha graduação com o meu TCC, sabe? Assim, eu tô no 10º. É porque, assim, é porque na UFPE... Então, pode falar faculdade? Pode, né? Enfim, na UFPE são 11 períodos, não são 10. E aí, porque eles colocam 14 eletivas pra gente pagar. E aí eu estou com 3 cadeiras. Eu podia terminar meu TCC esse período também, mas eu decidi ficar mais um período. E aí, enfim, estou no 11º, e período que vem estarei só com meu TCC.
Mulher, você tem quantos anos?
Eu tenho 22.
Nossa, novinha. Eu vou acabar a faculdade de por aí. Lá tá vendo, Laura? Lá eu tenho 23. Por isso que eu estranhei.
Nossa, meu Deus, velho.
Laura é a mais nova, que Laura vai pro quê? Pro segundo. Eu vou pro
Eu tô indo pro
quarto.
segundo semestre, eu tenho 19 anos.
Oh, meu Deus!
Nossa, que incrível!
Eu também tenho 19, mas vou fazer 20 agora. Em março.
Ai, gente.
Foram
Aproveitei muito o tempo acadêmico para fazer muitas competições, né? A gente tá aí no último ano possível.
As TEDs são assim, é a que vocês mais gostam? Vocês já fizeram outras também, né?
Não muito. A gente participava, né, muito de competição de mediação, negociação. Aí, multicorte, a primeira experiência foi com a Estética ano passado. Aí, esse ano, o ano passado agora, a gente foi para de do International Tribunal for the Law of the Sea, Direito do Mar Internacional. Foi ótimo também. E a terceira experiência do Corte agora. Mas Bia tem outras experiências também com Corte Americana e tudo mais.
Grande.
Eu não vi você lá, porque eu fui staff dessa da Itilus, né?
Foi? A de agora?
Fui. Eu levantava as plaquinhas.
Que ótimo. Eu gostei muito, eu achei o assunto incrível. Mas assim, eu acho que minha favorita é a Stetson. Apesar que eu gostei muito do assunto de direito do mar. Ai, gente, aproveitem que estão no início, vão para todas, enlouqueçam um pouquinho, porque é o que acontece. E, enfim, vai ser ótimo. Aí vocês são de qual faculdade?
Da UFBA.
Sim. A gente fez alguns amigos na UFBA, só que nas competições de mediação. Tem uma equipe bem forte lá, eles sempre angariavam o prêmio, é bem interessante.
Tem todos, acho que tem, de todas as competições, tem todos os subnúcleos lá na UFBA. É bem forte. Aí é bom porque dá para migrar, eu acho que tem uns 8, 9.
É como se fosse um grupo de extensão, um projeto de extensão que organiza a participação em competições.
Exato.
Tem um coordenador geral para todos os subnúcleos. De ambiental, de internacional público normal, de penal, de tributário, de
Legal.
vários. Nossa. É bom que dá para ficar migrando também, para você ter expertise em várias áreas.
Eu tenho interesse em participar em algum momento do multiporte de penal. Eu acho que deve ser.
Eu também.
Acho que deve ser pancado o multiporte.
Com certeza.
E tem o de direito internacional público também, que falam que porque a Stetson, pelo que eu ouvi, ela é um pouco mais tranquila. Acho que deu até para perceber pela condução da Nacional, né? A gente teve aquele tempo de conversar, de relaxar um pouco antes da competição, de fato. Você pode gesticular, você pode ser mais expressivo. Eu ouvi dizer que na de direito internacional público você não pode fazer isso. É seríssimo mesmo o pessoal lá e tal. Eu acho que deve ser... A pressão deve ser lá em cima.
Já levei uma bronca. Foi na Atlas, inclusive. Eles falaram que a gente tinha... Como que falaram? Não sei, meio que deram a gente estava atuando, né? Perdidas no personagem. E aí falaram pra gente calm down um pouquinho, sabe? Aí, enfim, nesse momento foi assassinado o Pinter britânico.
Olá, pessoal. Então, a gente vai colocar para dar um feedback bem rápido aqui para vocês. E só para dar um parênteses, a professora Solange viu a mensagem depois que faltou energia no escritório dela. Então, eu estava brincando com a Nathalie que a chuva que Beatriz falou foi para lá, para o escritório de Solange. Ela estava preocupada de que a internet dela, tudo na casa dela, acabou indo para lá. Mas, enfim, uma pena, infelizmente, mas a gente entende perfeitamente, né? Tudo bem, então, professora Nathalie, se puder começar dando um breve feedback para as equipes.
Em português mesmo?
Pode ser em português, fique à vontade.
Tá, então, primeiro, pessoal, parabéns a todas pela apresentação, eu gostei muito, vi muito profissionalismo, todas apresentaram muito bem os fatos, se manteram tranquilas, não demonstraram nervosismo, e eu me admirei muito que todas estavam muito bem preparadas, e mesmo sendo em inglês, todas demonstraram, né, aí conseguir repassar, né, o conhecimento, o caso, os fatos, o conhecimento jurídico também, responderam todas as perguntas também e conseguiram continuar com a argumentação durante, então me admirei muito com isso. Então, assim, só parabéns a todas, como eu disse, todas foram muito bem. E é isso.
Obrigado, professora. Então, eu vou falar bastante resumido, eu sei que também tem outros aqui assistindo, então fica uma dica geral. Antes de ir para as semifinais, final, revisem todas as perguntas que foram feitas, saibam perfeitamente as respostas possíveis, pesquisem, passem o dia de hoje e amanhã de manhã ainda pesquisando, pois elas são bastante interessantes, especialmente sobre linguagem limitante, soberania, outros casos específicos, o que a answer list é, como significa, como é que você sai dela, todos esses quesitos. Tenham pesquisado de hoje para amanhã para saber a ponta da língua. Mas, em geral, vocês foram muito legais. Estou feliz de ter acompanhado essa rodada. Realmente fiquei bastante feliz com o resultado e como vocês têm ido nessa competição. Então, obrigado a todos. Vamos tirar um print rapidinho para guardar de lembrança nosso fotógrafo virtual. 3, 2, 1. Perfeito. Depois a gente envia tudo para vocês. Até mais, pessoal. Vou deixar agora os outros entrarem na sala. Professora Nato, se quiser fazer uma pausa, daqui a uns 5 minutinhos, então, a gente retorna.
Tchau, gente. Foi um prazer, viu?
Obrigada.
Obrigada.
Obrigada, gente.
E obrigada, professora, também. Tchau, tchau.
Olá, pessoal que está entrando aqui agora. Vou pedir que vocês alterem seus nomes para constar o número da equipe, seguido letra A ou R, traço, cada dígito, o seu nome. Então, pessoal, vamos fazer uma conferência de tempos aqui. Essa é a roda S104. E nós teremos, na ordem de apresentação, Caroline, com 13 minutos, Gabriela, com 15, Marina, com 15, Kimberly, com 15. E com isso, a primeira equipe terá 2 minutos de réplica, correto? Perfeito. A pessoa que está como Mar Nascimento aqui é Marina Nascimento, correto? Isso. Assim presumo, né? Vou alterar aqui o número. Você é da equipe do Respondent, equipe 2696. Ok. S2696. R. Marina Nascimento. Perfeito. Ok, para atualizar, como vocês devem ter visto, a gente tem um cronômetro aqui virtual, que irá contar o tempo de vocês na fala de vocês. Eu vou enviar um vídeo depois para o grupo explicando como é que usa. É bem simples, mas para as próximas rodadas vocês poderem estar manuseando isso. E aí fica mais fácil vocês controlarem o tempo de cada um de vocês, fazerem mudanças, se for o caso, antes da rodada começar. mas por hora eu vou controlá-lo. Ainda só então uns 2 minutinhos, quando a professora Renata ali retornar, a gente dá início à rodada. E de novo, explicação, que presumo que vocês deveriam estar assistindo o vídeo, mas a professora Solange não pôde participar porque ela teve problemas de conexão, de energia no escritório dela, então eu assumi o lugar dela por hora. Olá, pessoal. Então, estamos prontos para dar início a esta rodada. Eu vou preparar aqui o temporizador, começando com Caroline para 13 minutos. Agent, when you're ready, you may proceed.
Thank you. Can Your Excellencies hear me well?
Yes.
Yes. Thank you. Your Excellencies, Ronco's Council, good morning. My name is Carolina de Caldas Bezerra, and I appeal on behalf of the Federal States of Anhur, the applicant in this case. I'll be addressing my speech for 13 minutes regarding the following issues. First, the construction of the hotel is hazardous for the Royal Ridley, highlighting this good wetland as a protected area. Second, Ronco violated transboundary harm. My co-agent Gabriela Bellotti will address Anhur's right to self-defense, the non-violation of humanitarian law, and finally, the no need for compensation to Ronco. With the kindly permission of this court, we would like to reserve 2 minutes for rebuttal. Your Excellencies, to contextualize my submission, on September 27 of 2020, the Rongoan Ministry of the Environment and Sustainable Development announced that it was granting a permit to build a hotel complex within the Scoot coastal wetland on Camp Key. Now, it is important to highlight that when Anhur acceded to the Ramsar Convention in 1987, Camp Key was still a part of Anhur's territory, and it was designated as a Ramsar site. The site has high biological value as it sustains an ample diversity of flora and fauna. In particularly, the area is an important nesting site for sea turtles, especially the critically endangered Royal Ridley. The beach area is the world's largest nesting site for the mentioned species, and it is estimated that approximately 35% of the nests from the global Royal Ridley population are located in the beach area. This information can be found on the record in page 7 and 12. What is the problem in the construction? Your Excellencies might wonder. The point is, first, the hotel will be constructed immediately adjacent to the nesting habitat. And second, the Lepidopteris, the genus which the Royal Ridley turtle is part of, it's considered by the International Union for Conservation of Nature as a critically endangered species, and it is listed in the red list of threatened species. We cannot be oblivious to the consequences for the turtles, and there are plenty. As a basis to quantify the damage to the species, a big national recovery plan was approved for the Camp Key Ridley sea turtle, promoted by Mexico and United States, seeking the protection of the Lepidopteris campi. This document lists a series of actions that threaten this very specific species. First, artificial lining is the greatest concern. Once this causes misorientation and disorientation of hatchlings, exposing them to terrestrial predators. Beyond that, the disorientation can lead to entrapped hatchlings in debris, vegetations, or vehicles. And even if the hatchlings successfully find the water, it can still be disoriented and draw back out of the sea. Following that, the introduction of other microorganisms and species by the water which accumulates in the ballast of the ship, which could lead to diseases and imbalance the ecosystem in general. And finally, this recovery plan affirms that coastal development increases human presence, causing the disturbance of nesting in emerging areas, pushing eggs by foot, and also heavy human traffic can compact the sand over nesting areas. It rests clear that this construction project will not protect a species that is already endangered and threatened in this world. Additionally, the Tamar project informs that construction could cause shading on the beach, decreasing the average temperature of the sand, which can increase the birth of male offspring and balance the populations of males and females. And also, pollution, which is expected in a tourist site, would directly affect the species feeding and locomotion life cycle. And also, the Tamar project informs that the most fatal thing that could harm the turtles is the pollution in beach areas, which be clearly expected in the hotel complex project by Ronco. Ronco cannot neglect a whole species and ignore the very likely environmental shift only by the premises of national sovereignty and the right of management of its own resources. The hotel complex aims to increase tourism, attracting a great number of visitors to the site that could represent a serious threat to the species and its reproductive success. Even if the EIA conducted highlighted the negative influence of lining on the species, still it wasn't excluded and it is planned to be set on the marina. Part of the hotel complex would be situated directly on part of the nesting habitat. Beyond that, that species is protected under the EIC. Once the Lipschodalis campi is listed in its annexes and establishes that all parties may adopt measures to protect and conserve sea turtles.
Agent,
It is,
one
yes,
quick
Your Honor?
question, just so I can guide my questioning correctly. Your co-agent will be talking about the other issues regarding the attack to the complex, right? Done by
Yes,
Nato. You're
exactly.
talking about more the second point specifically.
Yes, Your
All right.
Honor.
Just double checking. So about that, could you walk me through a little bit? What are the differences if we say that the wetland is like part of the respondent territory, part of the applicant territory? How does that make any difference towards the Ramsar Convention?
Yes, Your Honor. I would like to state that in the Vienna Convention of Succession of States, and also specifically in the Gapsikovo-Nagimaros project, it was stated that by the succession of states, some states are bound territorially by conventions, which is the case. The Kempki is the Ramsar Convention, actually, it's a convention that bounds states by the territory, by the wetland, and specifically. And in that case, the ICJ ruled that Hungary was binded by the river Danubio, and that's why the succession of states in this specific matter didn't need the approval of the state to continue their responsibilities under the convention. Did I fulfill your question, Your Honor?
Thank you, Agent. Yeah, and adding to that, are you familiar with the situation that was somewhat similar that happened in Crimea regarding Russia and the Ramsar site?
Yes, when Crimea was added to the Russian territory, it was a lot of wetlands located in the area, and specifically in the beach part, Russia would like to construct military agencies, as the Crimea, there is a large part of a beach, but in that specific matter, the construction the specific military construction was a project well done. Russia has a great military project. It's known for that. And in the Crimea, specifically, the military bases would be located in all beach area. It was a project much greater than this one that we are talking about. And it is also determined that parties should indeed restrict human activities that could seriously affect sea turtles as far as possible during periods of reproduction, nesting, and migration. Also, Article 8, Item D of the CBD provides that states each contracting party shall, as far as possible and as appropriate, to promote the protection of ecosystems, natural habits, and the maintenance of viable population of species in natural surroundings. Considering Rongo's previous action, UNWRA is very concerned with Rongo's ability to manage a protected environment, since achieving sustainable development requires constant monitoring and taking corrective measures. But Rongo has already shown that they do not pursue this continuous job with responsibility, once it failed to inform the Ramsar Secretariat of the changes in the Manhill Wetland Complex, as exposed on page 7 of the record. Not only, but also, Your Excellencies, Rongo has shown disregard when sent the diplomatic note on 6 November 2020, stating the non-obligation in fulfilling the Ramsar Convention, as its country itself did not designate the Scoot wetland as a Ramsar site. And we can find this inaccurate statement on page 13 of the record. Item 5 from Article 2 and Article 4.2 from the Ramsar determines that the parties have indeed the right to add, extend the boundaries of wetlands, or, because it's urgent natural interest, to delete or restrict the boundaries of wetlands already included, which is clearly not the case. Also, the contracting party should compensate as far as possible for any losses of wetland resources, and it should create additional nature reserves for the waterfowl and for the protection in the same area or elsewhere of an adequate portion of the original habitat. Now, even though the Camp Key is currently considered a part of Rongo's territory after the referendum of 2020, and as mentioned on page 11 of the record, once Scoot Coastal Wetland is designated as a Ramsar site, it is therefore protected under the convention. Your Honors, I find it very important to highlight one case in which the Ramsar Convention was seriously considered, the Cliff Marshall's Ramsar case. In December 23, the UK government concluded that internationally important status of some habits, in that case the Ramsar sites, and any potential adverse effect would require the government to demonstrate that it had considered all reasonable alternatives. Therefore, reconsidering the construction of an airport in a wetland internationally protected. Over and above that, Rongo has a responsibility to prevent extraterritorial damage. The third article of the CBD provides that states have sovereignty to explore their resources if it is guaranteed that those activities are not able to cause damage to the environment of other states. But where does this apply to the case at hand? According to the record, page 8, the Royal Ridley also spent part of their life cycle in Nahu's territorial waters, being part of Nahu's ecological niche. For this reason, once the Royal Ridley are threatened at the Scoot Coastal Wetlands, they would not be able to reach Nahu's territorial waters and fulfill that part in its ecological niche, damaging Nahu's biodiversity. That said, the court has already established in the pulp mills that a state is obliged to use all means at its disposal to avoid activities in its territory, creating significant damage to the environment of other states. In other words, this provision imposes a duty to protect neighboring states' biodiversity from activities carried out under their jurisdiction. That being said, and to conclude my submissions in the present matter, as proven in the previous topic and by the EIA carried out, the construction of the proposed hotel complex in the Scoot Coastal Wetlands has a great potential to interfere with the Royal Ridley turtle, contributing to endanger even more with the species, and because of that, it should not be allowed. I would like also to highlight the characteristics of the hotel. Even if Rongo takes mitigation measures in the lighting, there is no way that a hotel in this proportion that has 17 hectares, 340 guest rooms, 3,000 meter meeting space, and 4 restaurants will not have lights close to the beach. In fact, it is stated on the record that the permit would allow the use of spotlights in the hotel complex, balconies, stairways, parking lots, restaurants, and the marina for safety purposes. And also, the marina would comport 200 spots for vessels up to 100 meters length. Now, if the court has no further need of my assistance, I will conclude my submission and pass the floor to my co-agent. And I thank this honorable court.
Thank you, agent. Will the second agent just wait a minute before we proceed? As there seems to be an issue with the YouTube transmission. Just a second. Só um momento, pessoal. Basicamente, por alguma razão, as oradoras estão aparecendo com a tela preta para quem está assistindo. Somente eu e Nathalie estamos aparecendo com vídeo. Vou sugerir que vocês desliguem e liguem suas câmeras. Vai que isso resolve a situação lá no YouTube. Não sei. Eles estão tendo uma experiência de rádio, a moda antiga. Ok.
Rui, eu também tô com
Oi.
problema na minha câmera. Eu posso usar o computador da minha fellow
Claro.
agent?
Claro,
Ok.
fica à vontade. Vocês
Obrigada.
estão juntos, fica à vontade. Tá. Vou preparar o próximo tempo aqui, que seria Gabriela, 15 minutos, correto? Eu presumo que elas estejam se ajustando lá. Então, assim que ela voltar, a pessoa já vai reiniciar. Eu não consegui consertar ainda a questão do YouTube, mas a gente continua por aqui mesmo, normalmente. Pronto, posso iniciar o tempo, Gabriel? Está silenciada. Pessoal, vocês conseguem me ouvir? Da 2644? Perfeito, ok.
Como é que faz? Tem que apertar. Eu estava mudando meu nome, desculpa.
Sem problemas. Então, 15 minutos, you may proceed when you are ready to.
Thank you. Good morning, Your Excellencies, fellow council. My name is Gabriela Bellotti, and I appeal on behalf of the federal states of Unhur, the applicant in the present matter. For the next 15 minutes, I will be furthering the applicant's case by addressing the question regarding the alleged violation of international law by Unhur's response following the terror attack perpetrated in its territory. My speech will address the following points specifically. First, that Unhur rightfully exercised its right to self-defense. Second, that Unhur did not violate international humanitarian law. And finally, that Unhur has no duty to compensate Rongo. Your Excellencies, to contextualize my submissions, if we may look at page 8 of the record, we see that the Unhuri New Party Freedom Fighters, a paramilitary group, after setting up camp in Rongo, launched a major drone attack in Unhur that resulted in several civilian casualties, as well as destruction of both residential and government buildings. That attack then triggered Unhur's right to self-defense, who proceeded to locate and strike the NAPFF camp, successfully neutralizing the group. Now, Your Excellencies, the International Law Commission's draft articles on the responsibility of states in Article 21 specifies that the wrongfulness of an otherwise unlawful act is precluded if it is in conformity with the right to self-defense. Now, as a rule, the United Nations prohibits the use of force between member states, as seen in Article 2, Item 4 of the UN Charter. However, Article 51 of the Charter is an exception to that prohibition, allowing member states to act when an armed attack has occurred against them. Further, Your Excellencies, in case in which a state may be entitled to use force as self-defense against a private actor, and that group happens to be located in another state, the unable or unwilling doctrine applies. This doctrine states that if the host state does not have either the ability or willingness to stop the private actor's actions, the right to self-defense could very well be exercised. In addition to that, attempting to prevent the rise of terrorism, the UN Security Council published in 2001 resolution number 1373 that reaffirms a previous Security Council resolution number 1368 that condemned the terrorist attacks that took place on September 11th in New York City. Now, among other provisions, Article 2 of the former lists a series of measures that states shall take to contain the spread of terrorist groups, notably refraining from providing passive support to entities or persons involved in terrorist acts, as well as denying safe haven to those who finance, plan, support, or commit terrorist acts. Now, if we look at answer 10 of the clarifications, Rongo was not only aware, but also tolerated the NAPFF's presence in its territory, which at least is a manifestation of unwillingness to stop this group, and to do something about it. And at most, it can be regarded as passive support for terrorism even. Finally, but most importantly, self-defense must be necessary and proportionate. As stated by US former Secretary of State Daniel Webster in the notorious Caroline case, the necessity of self-defense must be instant, overwhelming, leaving no choice of means and no moment of deliberation. Additionally, the response to an armed attack must be proportionate to the threat. Striking
regarding self-defense, isn't self-defense only applicable when you're being attacked by another state and not regarding terrorist groups, paramilitary groups? Is that the case, or does it also include paramilitary groups like this one?
Your Excellency, the court in Nicaragua versus United States held that to use force against a private actor following an armed attack, that attack must be attributable to another state. However, the cases that we have on this matter, similar to this, notably Democratic Republic of the Congo v. Uganda, and also the construction of wall in occupied Palestine territories, are all cases in which the defensive uses of force were equally, if not exclusively, directed at the state from whose territory the non-state actors operated. For example, in DRC v. Uganda, the anti-Ugandan government group was located near the border. However, the attack, the alleged self-defense by Uganda, took place nowhere near the border. It took place in Congoan government buildings. Now, the court has yet to decide on a matter in which the use of defensive force is directed directly at the non-state actor, such as our case here. However, it's important to highlight that this does not mean that such use of force is completely ruled out. That said, Your Excellencies, the necessity of self-defense here is quite unquestionable, given the severe consequences of the attack to Unhur's population and infrastructure. Additionally, in Gapsikova Nagimar's project, this court has actually recognized the state of necessity principle as customary international law for exceptionally precluding the wrongfulness of an act not in conformity with an international obligation, as long as certain strictly defined conditions are met. This way, Unhur should be exempt from the obligation in Article 3.1 of the Rensselaer Convention in light of principles of self-defense and state of necessity, which could potentially override relevant treaty-based duties. Now, that said, the proportionality of the armed response deserves a more in-depth analysis. Firstly, Unhur made use of low-yield, appropriate, and more acceptable weaponry to conduct this operation, considering the type of target as well as the type of terrain. Now, for some context, as per answer 12 of the clarifications, 105 millimeter explosive rounds fired from M119 howitzers were used in the response against the NAPFF's attacks. Now, for some comparison, the International Tribunal for the former Yugoslavia prosecuted several cases regarding artillery action. From all of those weapons used in all of those cases, the only case in which the tribunal considered the ordinance to be more appropriate was in the Galich case, which is also one of with the lowest civilian casualty rate. Now, although the calibers used in Galich are no longer produced, they are the closest type of weaponry analyzed by the tribunal to the 105 howitzer round used by Unhur, and that is according to the manufacturer of the artillery weapons, BEA Systems. Also, the manufacturer's bulletin states that this kind of weaponry does not carry incendiary ordnance, therefore complying with the provision recognized by this court in nuclear weapons, stating that in cases of armed conflict, they always have to use a most suitable weaponry. Therefore, from all the available choices and considering that there were no civilians on the terrain since 1986, the 105 millimeter shell is considered to be a low-yield, acceptable alternative for causing less havoc. Lastly, in our proportionality analysis, Your Excellencies, we highlight that the armed response was not indiscriminate. According to the expert meeting in explosive weapons in populated areas conducted by the International Committee for the Red Cross, the usage of explosive weapons, although not being expressly regulated by international environmental law, must comply with international environmental law rules, particularly the prohibition of direct attacks at civilians or civilian objects and the prohibition of indiscriminate attacks. That said, as seen on the record and the clarifications, there were no civilians in the Manhit wetland complex, and the operations commander made it clear that a previous standard proportionality analysis was conducted, making sure that the damages caused were within the expectation. Now, Your Excellencies, for my second submission, even if the court dismisses—
Excuse me, I have a question. So you mentioned the principle of proportionality, but also another principle should be considered for the attack. So as the principle of necessity and the principle of distinction. So how can you explain that these principles were considered or not, and how?
Yes, Your Excellencies, all of these principles were all considered. For example, the principle of necessity states that the self-defense must be instant, overwhelming, leaving no choice of means, and also no moment for deliberation. And according to the record, the attack by the NAPFF took place on early November. The response took place on November 6th. This is a very short period of time, and UNHWR acted when it was UNHWR acted because the NAPFF strike them hard, causing civilian casualties and also destruction of great infrastructure. That's why the necessity here is quite unquestionable. And now for the principle of distinction that Your Excellency mentioned, the distinction here is that the attack was carried out on a military objective. Military objectives are objectives that by its characteristics serves a military advantage to the country that is striking them. So in this case, attacking the NAPFF camp served as a military advantage to UNHWR in successfully neutralizing the group, which would end up happening. Now, for my second submission, Your Excellencies, even if the court dismisses self-defense, UNHWR still did not violate international humanitarian law once it does not apply to the case at hand. Long before UNHWR's actions in 1986, when Rongo designated the Manhit wetland complex as a Ramsar site, the site's population was relocated, meaning that there were no civilians residing in the complex. Now, international humanitarian law seeks to set a set of rules that seek to limit the effects of armed conflict in relation to civilians and civilian objects, and with the sole purpose of protecting civilians. Now, given that there weren't any civilians to protect in the Manhit wetland complex, this cannot be a case of application of international humanitarian law. Now, even if it was applicable, UNHWR's actions in the complex could not have constituted violation of IHL, because in this case, UNHWR has never consented to be bound by any treaty that relates environment and armed conflicts, let alone a treaty that extends civilian character to the environment. Additionally, such provision has yet to rise to the level of international customary law to have any binding force. Therefore, there is no violation by UNHWR here. And finally, for my final submission, because of the environmental conditions of the Manhit wetland complex, UNHWR cannot be held responsible for all the damages.
Before you go there, on the topic of necessity, even if we don't consider it a civilian character in nature or anything like that, hasn't this court said that it is an essential interest of a state, and thus it would preclude you from applying the doctrine of necessity here, because you'd be affecting an essential interest of the respondent, which this court has recognized that the environment is an essential interest. So wouldn't this preclude necessity from being applicable?
In the case of necessity, The violation of essential interest by another state is one of the conditions set in Gapsikov-Nagimaros. However, as per Article 21 of the ILC's draft articles, self-defense overrides any sort of provision, even primary rules, for example, the prohibition of the UN on the use of force. So for my final submission, we will enter the compensation realm, and Article 12 of the United Nations Responsibility of States for Internationally Wrongful Acts states that there is a breach of an international obligation by a state when an act of that state is not in conformity with what is required of it by that obligation. Further, this court, in certain activities carried out in Nicaragua, infer that for a state to have responsibility and obligations over transboundary harm damages, it first must be concluded if the activities even have the potential to cause the alleged damage. Now, analyzing the conditions surrounding the damage that occurred in the wetland complex, it is clear that Rongo is responsible. And Your Excellencies, I see that my time is coming to an end. And for the rest of our stance on compensation, I will refer you to our written memorials. And for the foregoing reasons, I respectfully request that the court find in favor of the applicant to judge and declare that the actions of UNHUR with respect to the Menhe wetland complex violate international law, while Rongo's actions regarding the proposed hotel project in the skewed coastal wetland did not violate it. Now, unless the court has any further questions, that concludes my submission on behalf of the federal states of UNHUR. I thank the court for its indulgence. May it please the honorable court. It was an honor.
Thank you, Agent. And the first agent for the respondent, Marina, you may proceed when you're ready for it. You'll have 15 minutes, correct?
Yes, correct. Can you hear me well?
Yes.
Thank you. Good evening, Mr. President, Your Excellencies. May it please the court. My name is Marina Nascimento, and I have the honor to appear on behalf of the public of Rongo, the respondent in today's proceedings. For the next 15 minutes, the respondent will proceed to address applicant's arguments regarding the actions of UNHUR concerning the Menhe wetland complex. My co-agent, Kimberly Oliveira, will address the second issue concerning the hotel developments in the skewed coastal wetland for 15 minutes. Your Excellencies, over the course of the next 15 minutes, I will be submitting the following 3 points. Firstly, UNHUR failed to notify and cooperate with Rongo and also violated Rongo's sovereignty. Secondly, UNHUR violated international environmental law by attacking the Menhe wetland complex. Thirdly, UNHUR has the obligation to compensate Rongo for the damage caused in the Ramsar site. Beginning with the first topic, shortly after the MPFF attack on 6 November 2019, UNHUR fired explosive artillery rounds at the Menhe wetland complex without any attempt of notification or cooperation towards Rongo. Cooperation is a very well-established principle in international law, and it is mentioned in several documents, such as in Article 5 of the Convention on Biological Diversity, that states that contracting parties shall cooperate with each other in respect of areas beyond national jurisdiction and on other matters of mutual interest for the conservation and sustainable use of biological diversity. The United Nations Charters in its Article 1 and 3 also entails cooperation among states in the maintenance of international peace and security, as well as in the solving of international problems of an economic, social, cultural, or humanitarian character, as it is in this case. Furthermore, UNHUR's action clearly caused transboundary harm, a principle that is recognized by customary international law and also mentioned by the Convention on Biological Diversity in its Article 3 and also by the Rio Declaration in its Article 19. UNHUR had the responsibility to ensure that activities within their jurisdiction or control do not cause damage to the environment of other states or of areas beyond the limits of national jurisdiction, and thus it violated international law. Furthermore, the obligation to notify other states of plans that may have transboundary impact is intended to create the conditions for successful cooperation between the parties. The Rio Declaration states in its
before you move on to that topic, just
Yes,
a quick question. Which transboundary harm principle did they violate? The duty to prevent or the duty not to cause transboundary harm? And if so, like, what's the difference legally on each of them?
Yes, they violated the duty to not cause transboundary harm because transboundary harm occurs when there is a significant consequence to a state's environment or wildlife as a result of human activities held in other states' territory, including the ICJ already decided a case concerning the transboundary harm, which is the Corfu Channel judgment, and also in the ICJ's advisory opinion on the legality of the threat or use of nuclear opinions. Also, the Rio Declaration, it states in its principle 18 that states shall immediately notify other states of any emergencies that are likely to produce sudden harmful effects on the environment of those states. This obligation is also supported by this court in the Pope Mills on the River Uruguay of 2010. By failing to comply with this term, Unhur and Rangel could not assess the risks of the plan and negotiate possible changes, and therefore violated international law. In this sense, as it was declared in this court's case, Nicaragua versus the United States in 1986, customary international law allows collective self-defense, but Unhur failed to comply with the circumstances required for the exercise of this type of self-defense. Firstly, the state must declare itself as a victim of an armed attack. Secondly, in the case of collective self-defense, the victim state must request assistance. The court held that there is no rule permitting the exercise of collective self-defense in the absence of a request by the state which regards itself as the victim of an armed attack. Thirdly, even though the state that is attacking does not have the obligation under Article 51 of the UN Charter to report to the Security Council that an armed attack happened, the court held that the absence of a report may be one of the factors indicating whether the state in question was itself convinced that it was acting in self-defense. And lastly, the force used must be necessary and proportionate. In this sense, Unhur did not declare itself as a victim of an armed attack, nor requested assistance, because as mentioned earlier, shortly after the MPFF attack, Unhur fired the artillery rounds at the Manhit wetland complex, and Rangel did not receive any request for assistance from Unhur. Furthermore, no report was sent to the Security Council, questioning even more if the attack can be considered self-defense. Lastly, not only this case requests that the force used be necessary and proportionate, but also customary international humanitarian law, which states that no part of a natural environment may be attacked unless it is a military necessity. The customary international humanitarian law states in its 14th rule that damages caused to the civilian population during a military attack shall not be excessive in comparison to the direct military advantage obtained. The paramilitary group.
I have a question. So before Unhur conducted a proportionality analysis prior to its military operation, so doesn't this satisfy its obligation of due regard toward the environment?
Yes, Your Excellency. Actually, it fulfills part of the obligation, but since the paramilitary group launched attacks that destroyed one government building, 2 residential buildings, and killed Unhur citizens, the attack launched by Unhur burned 80,000 hectares of the peat swamp, a World Heritage Preserved site, resulting in widespread, long-term, and severe damage to trees and vegetation, soil, and wildlife. So the attack carried by them should not have this impact. They violated several international environmental laws. And in this sense, the respondent claims that the applicant's action was not proportionate. The used methods must regard the protection and preservation of the natural environment, so all precautions must be taken to avoid and minimize the damage in the conduct of military attacks. Regarding the necessity, it is important to emphasize that Unhur had other options before firing the artillery rounds and destroying great amounts of the man-made wetland complex, such as cooperation with Rongo, as previously mentioned, or UNHUR could have warned the insurgents to require cessation from the hostilities. In this sense, UNHUR had the duty to use non-violent means wherever possible, and especially the duty to use only the minimum necessary force that is reasonable in prevailing circumstances as required by international law. Moreover, Article 2, Paragraph 4 of the United Nations Charter declares that states are forbidden from using force in the territory of another state. This prohibition is characterized as use clause by this article. UNHUR has the obligation to notify Rongo about plans that have transboundary impact. The applicant may claim self-defense, which is an exception to the article mentioned. However, in this case, Article 51 does not permit the use of armed force targeting non-state actors on the territory of another state without its consent. Therefore, UNHUR's attack on the MPFF paramilitary group cannot be characterized as self-defense, since non-state actors cannot use force within the meaning of Article 2, Paragraph 4, and so cannot carry out an armed attack within the meaning of Article 51. Moreover, UNHUR violated international humanitarian law. First, it is important to emphasize that this case can be considered an international armed conflict. According to the International Committee of the Red Cross, the hostilities between a foreign state and a private actor are in fact non-international armed conflict. However, the relationship between the foreign state and the territorial state has not consented the use of force in its territory. This court also supports this position in the case Democratic Republic of Congo versus Uganda of 2005. The environment must be protected during all times, especially during armed conflicts. It is recognized that the environment is an important civilian object. UNHUR breached the customary principle of distinction between civilian objects and military objectives, which, according to the International Committee of the Red Cross, the environment is covered by general provisions regarding warfare, and thus the attacks can only be directed to military targets. Since the attack was aimed at the man-made wetland complex, an object that is civilian by nature, and it is utilized by non-combatants, such as small groups engaged in guided wars, there has been a breach of international law. Furthermore, the Ramsar site can also be considered to have a civilian character due to its ecological importance for the international community, and also because it is part of the natural environment in light of Principle 13 of the ILC draft principles on the protection of the environment in relation to armed conflict. Even if this court considers that the applicant's attack was directed to a military objective, the attacks should be limited to the MPFF's camp. However, this strike destructed a huge portion of the Ramsar site, a civilian object by nature. Furthermore, the paramilitary group used drones brought from UNHUR territory to attack their own nation. UNHUR could confiscate the arms used for military operations and destroy or seize in a specific circumstances that is the most effective means of combating. The US use of drones in Pakistan as aircraft to targeted killings in a controversial human rights issue according to the International Amnesty, which already opinions that could be considered a war crime. The International Amnesty recommended to the international community to permit the international transfer of drones weapons in circumstances where there's a substantial risk the recipient would use the weapons to commit serious violations of international human rights law or international humanitarian law. Moving on to the next point, it is reasonable to consider that Ramsar Convention and the World Heritage Convention are applicable during armed conflicts. Thus, UNHUR failed to comply with the World Heritage Convention. Article 6 lays out the responsibilities of the international community to cooperate and protect the world heritage, and also not to take any deliberate measures which might damage directly or indirectly the cultural and natural heritage. Thus, UNHUR failed to give due regard for the natural environment during military operations. Principle 7 of the Rio Declaration on Environment and Development, an event that both UNHUR and Rongo fully participated in, declares that states shall cooperate in a spirit of global partnership to conserve, protect, and restore the health and integrity of the Earth's ecosystem. UNWRA's artillery round sparked a high-scale fire that burned 65% of Rongo's environmentally protected area, causing irreparable damage. It is important to emphasize that Rongo did not violate Article 3, Paragraph 2 of the Ramsar Convention. This article states that states parties to this convention should inform the Ramsar Secretariat if the ecological character of a Ramsar site has changed, is changing, or is likely to change as the result of technological developments, pollution, or other human interference, which constitutes a traceable interference. The ecological change
Agent.
at the manhole. Yes.
I get that point. Before we run out of time, I'd like you to give me an overview or a short answer on what would have been the legal choice for the applicant in regards to protecting themselves in the view of the respondent. What would have been the legal choice that the applicant could have chosen that would protect him?
Yes, Your Excellency. As previously mentioned, cooperation was the way. Since UNWRA did not notify Rongo of the attack, there was no way they could talk about the ways to proceed. So since they didn't talk, the damage caused was irreparable. If Rongo had notified, as it should have, the Rongo could have helped towards the situation. Did I answer your question, Your Excellency? Thank you. Now, Your Honors, moving on to the third and final claim, UNWRA has the obligation to compensate Rongo for the damage caused in the Ramsar site during the attack on the parliamentary group. Mr. President, would you give me 30 seconds to finish my submission? Thank you. So the attack by UNWRA sparked a fire through Rongo territory and damaged 65% of the Ramsar site. Under Article 10 of the RC Articles on Transboundary Harm and Article 31 of the ILC report of 2001, the applicant is obliged to fully repair the harm caused to the manmade wetland complex. The ICJ has already awarded compensation for both environmental damage and for the costs and expenses incurred in concerning a Ramsar site in the Nicaragua versus Costa Rica judgment. So this implies that UNWRA has the duty of compensation for the damage caused by activities beyond its jurisdiction. This concludes my submission. If I can be of no further assistance to this court, I now pass the floor to my co-agent. Thank you, Your Excellencies.
Thank you, agent. Your co-agent will also speak for 15 minutes, correct?
That's correct. Can everyone hear me well? So,
yes.
Thank you, Mr. President, Your Excellencies. My name is Kimberly Oliveira, and as stated by my co-agent, I will be guiding this honorable court through the second issue, whether the actions of Rongo with respect to the proposed hotel development and the skewed coastal wetland violate international law. Your Excellencies, over the course of the next 15 minutes, I will be submitting the following 3 points. Firstly, that Rongo is performing its affirmative obligations to take measures to conserve the skewed coastal wetland. Secondly, that there is no violation of the Inter-American Convention for the Protection and Conservation of Sea Turtles. And thirdly, that Rongo took appropriate and proportionate measures to mitigate the harm derived from the proposed complex. Beginning with my first topic, Rongo is performing its affirmative obligations to take measures to conserve the skewed coastal wetland. Rongo considers the skewed coastal wetland as part of their territory, and in this sense was not named as a Ramsar site. Moreover, the Ramsar Convention states in its Article 2 that the inclusion of a wetland in the list does not prejudice the exclusive sovereign rights of the contracting party in whose territory the wetland is situated. Therefore, as a sovereign state, Rongo does not recognize the skewed coastal wetland as a Ramsar site. Rongo recognizes, however, that the Ramsar Convention in its Article 4.1 states that any party has the duty to preserve wetlands regardless of their status as a site, through the establishment of nature reserves and the provision of adequate wardening. In accordance with the Vienna Convention on the Law of Treaties of 1969, the state is complying with obligations in good faith, carrying out its liabilities and duties, and promoting the preservation of the wetland in accordance with its national legislation. Furthermore, the delisting requirement prescribed by Article 2.5 of the Ramsar Convention does not apply, as this requirement is done by the same state which sent the notification to the Secretariat to submit the wetlands to the list. By not having been nominated by Rongo and by being under Rongo's dominance, the skewed coastal wetland is not a Ramsar site. Moreover, there is no violation of positive obligations arising from Article 4, as there is adequate wardening of the wetland. It is important to emphasize that nor the Ramsar Convention or its resolutions impose a prohibition on development. On the contrary, sustainable development is encouraged so as long as mitigation measures are put in place. The proposed hotel complex project is fully consistent with the Ramsar Convention's Resolution 11.7, as it recognizes the importance of sustainable tourism in and around wetlands for development and poverty alleviation. Moreover, the wetland conservation and wise use provides a meaningful experience for visitors while raising awareness to the wetland.
I have two questions here. Let me start with the first one when you were talking about the obligations under the Ramsar Convention. If we assume for a moment that Kemki is actually part of the respondent's territory, wouldn't it have inherited all the obligations that the applicant had in that situation?
Your Excellency, I understand your concern, but the Vienna Convention on Succession of States and Respect of Treaty states in its Article 15 that when part of a territory, or when any territory for the international relations of which a state is responsible, not being part of the territory of the state beforehand, becomes part of which a state is responsible, treaties that the predecessor state had signed cease to be enforced. So in relation to the obligations that UNHOR comply to cease to be enforced. But seeing, even if we take into account that Rongo is a signatory to the Ramsar Conventions, we submit that by not having been nominated by Rongo, Rongo could not request the listing as prescribed by Article 2.5. And in this sense, is not to be considered as a Ramsar site.
All right. And secondly, on the other topic, you brought up the subject of some resolutions, right? To say that it was in agreement with it. And they're generally not binding. But since we're talking about resolutions, would you say that these actions are not consistent with, let's say, Resolution 11.9, 13.24, and even the one you mentioned, because it says that it needs to maintain the ecological character. And I mean, we don't have many studies to show for it, but quite frankly, it seems weird that this proposed resort would not impact in any way the diversity or the animals that inhabit that area.
Your Excellency, what the respondent submits is that there is harm to be expected from the proposed complex, but Rongo is complying with its provisions of the Ramsar Convention and its resolutions when mitigation measures are put into place. In this sense, sustainable tourism is defined by the UN Environment Programme and UN World Tourism Organization as tourism that takes full account of its current and future economic, social, and environmental impacts, addressing the needs of visitors, the industry, the environment, and host communities. In this sense, the mitigation measures put into place serve to compensate or offset any of the impact that will be generated by the construction of the proposed complex. In this sense, Your Excellency, the 1992 Rio Declaration established that the environmental protection constitutes an integral part of the development process, while also recognizing the need to eradicate poverty. There must, however, be a cautionary approach to projects which damage the environment, impairing sustainable development. In this sense, the environmental impact assessment was done exactly to prevent any irreversible damage. Moreover, Excellency, Resolution 13.24 stresses the importance of, whenever possible, reducing threats to nesting areas, such as noise and light pollution. The duty of taking appropriate and necessary measures for the protection and conservation recovery of sea turtles and their habitats is expressly determined in the IAC's Article 4. Being a signatory of this convention, Rongo is complying with its provision. The same convention imposes in Article 4.2c that to the extent practicable, human activities that could seriously affect sea turtles must be restrained. And this is exactly what the respondent is doing by requiring the installation of shade screens or window tinting in windows and glass doors facing the beach to block interior lights and maintaining only the spotlights for safety purposes. The African Court on Human Rights, in the case of Social and Economic Rights Action Center and the Center for Economic and Social Rights versus Nigeria, decided that a government's lack of action to stop the contamination of the environment resulted in a violation of the right to a healthy environment. In this sense, Rongo's government is making sure that the proposed hotel complex project is done in accordance with national law and imposing measures to safeguard the wetland. Therefore, Rongo is complying with the obligations arising from international law and did not violate norms deriving from the Ramsar Convention and its resolutions. Moving on to my second point, there is no violation of...
I have a question. So permitting a hotel complex and a marina near and on part of the turtle's nesting habitat is not inconsistent with the objective of the AIC?
Your Excellency, what the respondent is submitting is that nor the convention or any of the resolutions impose a strict ban on all development. They do require the installation of mitigation procedures or measures. In this sense, Rongo could restrict for example, the vessel activity during the periods of reproduction and nesting of the royal ridley. In this sense, Your Excellency, measures that serve the purpose of compensation or offsetting of the mitigations are enough to compensate for any harm proposed for the environment in the area of the proposed complex. Moreover, Your Excellencies, the American Convention on Human Rights sets forth a progressive development obligation under which states are required to adopt measures to achieve the full realization of the rights listed in it. This requirement has been previously interpreted as incorporating the right to a healthy environment within the economic, social, and cultural rights. The court relied on its interpretation of the right to a healthy environment in its advisory opinion 2317 of 2018, in particular, as it refers to the content and scope of the right to a healthy environment, and thus incorporated the right to a healthy environment among the rights protected by Article 26 of the American Convention, given the obligation of states to achieve the integral development of its people. Moreover, Excellencies, the preamble to the additional protocol of the American Convention on Human Rights in the areas of economic, social, and cultural rights emphasize a close relationship between the exercise of economic, social, and cultural rights, which include the right to a healthy environment, and of civil and political rights, and indicates that the different categories of rights constitute an indivisible whole based on the recognition of the dignity of human rights. The principle of prevention of environmental damage forms part of international customary law. This protection encompasses not only the land, water, and atmosphere, but also includes flora and fauna. To respect and to ensure the rights to life and to personal integrity of the persons subjected to their jurisdictions, states have the obligation to prevent significant environmental damage. And in this sense, the environmental impact assessment was done by Rongo to regulate, supervise, and monitor activities within its jurisdiction that could produce significant environmental damage. Moreover, Excellency, the state of Rongo prepared a plan to establish safety measures and procedures to minimize the possibility of major environmental accidents. and is mitigating any significant environmental damage that may occur. Moreover, according to the Convention on Migratory Species Resolution 1223 on Sustainable Tourism and Migratory Species, general principles for ensuring that tourism activities benefit from and do not harm migratory species includes the involvement of and benefits to local communities, and this should be provided by the national legislation. When taken into account the poverty of the local population, the lack of governmental measures capable of reversing or mitigating the consequences would constitute a violation of the rights remedy. And finally, Your Honors, moving on to my last point, the proposed hotel complex includes measures for protecting the population of sea turtles. The IAC provides an exception to the restriction on human activity as provided by Article 43A. The state may allow exceptions to satisfy economic subsistence needs of traditional communities. In this sense, and as stated by the facts, the proposed hotel complex would increase ecotourism and help the impoverished local community. The IEC also states that by allowing a provision, an exception as provided by this aforementioned article, the state is required to establish a management program that includes limits on levels of intentional taking. In this sense, it must be highlighted that after the completion of the environmental impact assessment, it was determined by the Uruguayan Ministry of Environment and Sustainable Development that the building permit would require certain measures to ensure the mitigation of the harmful effects of the complex's use of light. In this sense, yes, Your Excellency?
That topic is a bit clearer for me as well. Let me ask you something so that it can guide our decision making. You've mentioned a lot of resolutions here, both in favor, especially in favor of your point of view of your country. How should this court deal legally with resolutions that are by nature non-binding? What way should it give to those resolutions when interpreting the convention? How should we deal with that in order to define whether or not you violated the purpose of the Ramsar Convention, for instance?
Your Excellency, what the respondent submits and asks this court to declare is that the resolutions are binding upon the states, but especially the Ramsar resolutions, they have no mechanism to enforce said provisions. So this court has the power to enforce a legal obligation on states to follow the provisions set out by the resolutions. Moreover, if we take into account the global environmental concern and the need to eradicate poverty, we cannot allege a violation of international law as Rongo took appropriate and proportionate measures. Finally, if this satisfies Your Excellency, I would like to proceed to my final statement. As Indira Gandhi stated in her speech at Stockholm at the launch of the National Committee for Environmental Planning and Coordination, are not poverty and need the greatest polluters? Your Excellency, I see that my time is up, so I thank you, this court, for its time. This concludes my submissions.
If you'd like an extra 30 seconds or so to finish.
I appreciate that, Your Excellency. So I will now proceed to my prayers. The respondent hereby requests the court to declare that, firstly, the federal states of Unhur did not violate international law with respect to the man-made wetland complex. Secondly, that the Republic of Rongo, Unhur did violate, and Rongo did not violate international law with respect to the proposed hotel development in the skewed coastal wetland. If Your Honors have no further questions, I rest my case. It was an honor to argue before this respectable court today. May it please the court.
Thank you, Agent. The agent for the applicant may proceed with the rebuttal for 2 minutes, right?
Your Excellencies, first and foremost, the applicant would like to highlight that the respondent mentioned that the Manhe Wetland Complex is on the World Heritage Convention list. However, according to the record, it was not approved to be on the World Heritage Convention list. And this only shows the plain disregard of the respondents towards their own wetlands. Secondly, the respondent also mentioned that there was no military necessity and that Unhur's response was excessive. However, the use of appropriate military weapons and also drones to be able to locate and strike, specifically strike the NAPFF's camp, shows that UNHUR took the measures to comply with this court's understanding that proportionality of the unarmed attack should take into account the least possible alternatives. Finally, we would like to highlight that the fire only propagated in the wetland because of the drought conditions, extended drought conditions since 2014, according to the record, something that the applicant forgot to mention. Now, the respondent forgot to mention, I apologize. Now, according to, as per the hotel, we would like to highlight that it seems unreasonable to say that even though the EIA only came up with the lighting, it's unreasonable to say that a hotel that will have 17 hectares, 304 guest rooms, over 3,000 space for meeting areas will only have internal lighting as its impact. Therefore, it is unreasonable to say that. Thank you, Your Excellencies, for your time.
Thanks, everyone. This court is now session adjudged. We will discuss and deliberate and be back soon for feedback.
Oi, gente, tudo bem?
Oi, gente.
Oi,
Parabéns, vocês foram muito bem.
O sentimento é mútuo.
sim, definitivamente.
Eu assisti a rodada de vocês de ontem. Eu tava super nervosa, tipo, meu Deus, essas meninas vão destruir. O que eu vou fazer?
Imagina. Vocês foram muito bem também.
Uhum.
Tá indo todo mundo muito bem. Tô impressionada.
O nível tá super alto.
Vocês já participaram de outras competições ou é a primeira de vocês?
Não, é minha primeira.
Uhum.
Tá brincando?
Não.
Meu Deus, vocês estão muito bem. Na minha primeira vez, nossa, se o juiz mencionava que ele ia fazer uma pergunta, eu já ficava tipo, sabe? Não. Vocês responderam muito bem.
Obrigada.
Dá um nervoso mesmo, né?
Ai.
Vocês sabem.
Nossa, eu vou provar que eu tô mudando.
Olá, meninas. Então, a gente já deu uma analisada, já conversamos um pouco sobre o que aconteceu durante a sessão, tá? Então, eu venho aqui só para parabenizar vocês pela argumentação. Gostei muito do trabalho de todas, acho que todas foram muito bem, se prepararam muito bem para as apresentações. E, bom, é isso. Parabéns para o trabalho, pelo trabalho que eu ia com você.
Pois é, pessoal, estou realmente bastante impressionado com o nível de todo mundo, tá todo mundo sabendo bastante das coisas, diversos aspectos. Sempre há tópicos para melhorarem, eu vou falar alguns específicos aqui. Acho que eu já falei algumas outras rodadas, vocês podem notar, reassistindo. Mas foquem bastante também em questão de resoluções, o standing legal delas, a questão da sucessão de obrigações também de tratados e em geral, queria dizer que eu gostei bastante de aprofundar se vocês tiverem a analisar aspectos não legais, não jurídicos da questão, porque, obviamente, eles influenciam bastante a resolução jurídica da questão, especialmente se tratando de direito ambiental, em que muita questão provém dos fatos da vida e não somente do direito posto. E como vocês sabem, tem cláusulas muito abrangentes, nem tudo é perfeitamente regulado, ou muito pelo contrário, na maioria das vezes você tem cláusulas que dizem assim, protejam o ambiente, e você tem que saber como usar aquilo ali de maneira mais enforcing, né? Então, de maneira geral, parabéns a todos, muito legal, espero revê-los mais tarde, alguma equipe certamente, e amanhã temos as semifinais e final da competição. Boa sorte a todos. Vamos tirar uma foto rápida aqui, para guardar de lembrança. 3, 2, 1. Perfeito, pessoal. Depois a gente vê para vocês. Obrigado, professora Nathalie, pela participação. Foi um prazer tê-la aqui conosco.
Eu que agradeço. Foi um prazer.
E até uma próxima. Tchau, tchau, pessoal.